Hey, New York. Welcome to the NY Weekly Record, where we follow the documents, question the official story, and keep New York's public systems under a very bright spotlight. I'm Michelle Evans, and this week, we have police reform facing its first real courtroom test in the Bronx. We have New York City schools potentially leaving hundreds of millions of federal dollars on the table, while families fight for special education services. We have another young man dead after entering city custody. And we have tenants who stepped outside and came back to find the locks changed on their own homes. Courts, schools, jails, housing. Different agencies, different neighborhoods, same question. When government institutions hold power over people's lives, who makes sure that power is being used responsibly? We have 4 major New York stories to break down. So get comfortable, pay attention, and let's get into the record. The chokehold law is now on trial. New York City passed its police chokehold law in 2020 with a very clear message. Officers cannot restrict a person's breathing or blood circulation by compressing the neck. It was passed after the police killing of George Floyd during a national demand for police accountability. Now, 6 years later, that law is finally facing a major courtroom test in the Bronx. NYPD officer Omar Habib is headed to trial in what prosecutors say is the borough's first criminal prosecution of an officer under the city's chokehold ban. The allegations come from a July 2023 encounter at an Eastchester Road catering hall. Prosecutors say Habib wrapped his arm around a man's neck, restricted his breathing or blood flow, and caused him to temporarily lose consciousness. Habib has pleaded not guilty. That matters. An indictment is an allegation, not a conviction, and prosecutors must prove every charge beyond a reasonable doubt. But this trial is about more than one officer. It is also about whether the law itself has teeth. Passing a reform during a national protest is one thing. Enforcing it against a police officer in an actual criminal courtroom is something else entirely. Jurors may hear testimony, review body camera footage, and examine what happened during a fast-moving police encounter. But outside the jury box, New Yorkers will be asking broader questions. What training did officers receive? What supervision followed this incident? Were warning signs identified? And when the city tells the public that a dangerous restraint has been banned, does that ban produce real accountability or just another policy on paper? The courtroom will decide Habib's guilt or innocence. But the trial will also show whether one of New York City's most visible police reforms can survive contact with the criminal justice system. That is why this case matters. The chokehold law is not just being cited, it is being tested. NYC schools may have left $431.6 million unclaimed. That is the amount New York City public schools may have failed to collect in federal Medicaid reimbursements connected to special education services over 3 fiscal years. Let that number settle in, because this is not simply an accounting mistake. This money was connected to occupational therapy, physical therapy, speech services, counseling, and other support that students with disabilities may be legally entitled to receive. According to a follow-up audit from the New York City Comptroller's Office, auditors identified hundreds of millions of dollars in potentially unclaimed reimbursements, missing service documentation, and services the school system decided not to bill. Nearly 20% of the required services reviewed reportedly lacked proper records, showing that the services had actually been delivered. That creates 2 problems at once. First, the city may lose federal reimbursement. Second, and more importantly, families may be left without reliable proof that their children received the services promised in their individualized education programs. The school system disputes the audit's estimates and says some of its assumptions overstate what could realistically have been collected. Fair enough. Not every dollar identified by an auditor automatically becomes a collectible dollar. But here is what cannot be brushed aside. A previous audit made 30 recommendations. The follow-up found that only 3 had been fully implemented. 3 out of 30. So the question is no longer whether the system was warned. It was. The question is why so little changed. New York City families already spend enormous time fighting for evaluations, placements, therapies, and accommodations. They should not also have to wonder whether the city documented those services correctly, or whether hundreds of millions in available support disappeared into administrative failure. This is not just money left on the table. It is accountability left unfinished. Julian Pagan died after arraignment. Julian Pagan was 29 years old. On Friday, July 24th, he was found unresponsive inside a Bronx courthouse holding cell after his arraignment. Department of Corrections staff provided medical assistance, according to the agency, and Pagan was transported to Lincoln Hospital. He was pronounced dead at 6:37 p.m. His cause of death has not been released, and right now, the public record contains far more questions than answers. When was Pagan last seen conscious and responsive? What medical screening did he receive? Did he complain of pain or illness? How frequently was he observed? Who was responsible for monitoring the holding area? And exactly when did custody transfer from the court system to the Department of Correction? These details matter because Julian Pagan was under government control. The city had a duty to keep him safe. And although he died after being held at a courthouse, not on Rikers Island, the location does not reduce that duty. It expands the accountability question. People move through several stages after an arrest: precinct custody, transportation, courthouse pens, arraignment, and sometimes transfer to jail. Safety cannot begin only after someone reaches Rikers. It must exist at every stage. Pagan's death is reportedly at least the 5th involving someone who died in or shortly after Department of Correction custody during 2026. At least 15 people died in city jail custody in 2025. Those numbers cannot become background noise. The commissioner has promised an investigation, but condolences and promises are only the beginning. Pagan's family deserves the medical findings. They deserve the observation records. They deserve the staffing assignments and emergency response timeline. They deserve to know how a 29-year-old man entered a Bronx courthouse alive and left city custody on the way to a hospital where he was pronounced dead. That answer must not disappear behind another agency statement. His name was Julian Pagan, and New York City owes his family the truth. They changed the locks while tenants were outside. Imagine stepping outside your apartment to take out the trash. Then you turn around, walk back to your door, and your key no longer works. Your identification is inside. Your coat is inside. Your medicine, documents, and belongings may all be inside. But the locks have been changed. That is what New York Attorney General Letitia James says happened to lawful occupants in buildings managed by Spigro Management. The company manages more than 3,000 apartments across more than 40 New York City buildings. According to the Attorney General's office, an investigation confirmed at least 4 illegal lockouts in Brooklyn and the Bronx between 2020 and 2025. One tenant, Michael Brown, had lived with his adoptive mother for more than 20 years. After she died, Brown said he stepped outside to take out the trash and returned to find the lock changed. He was reportedly homeless for 9 months while fighting to get back into the apartment. 9 months. Because someone allegedly decided that changing a lock was easier than following the law. In New York, a person who has lawfully occupied a home for at least 30 days generally cannot simply be removed without a court order and the proper eviction process. The property manager does not get to become the judge, the marshal, and the entire housing court by replacing a lock. Under the settlement, Spygro and its lead property manager must pay penalties and restitution, adopt a formal lockout policy, and document the legal authority behind future lock changes. They did not admit wrongdoing, but the agreement also requires 3 years of monitoring. And this problem is bigger than 4 tenants. City Council data cited in the reporting showed more than 1,800 illegal lockouts during a recent 1-year period. One change lock can lead to homelessness, lost medication, missing documents, and months of instability. Housing court exists for a reason. Due process exists for a reason. Nobody should leave home to take out the trash and come back to find that their entire life has been locked behind someone else's decision. And that is this week's NY Weekly Record. A police reform facing a courtroom test. Hundreds of millions in potential education funding left unresolved. A 29-year-old man dead after arraignment. And New Yorkers allegedly locked out of the places they called home. These stories may look separate, but they all come back to one thing: accountability. Rules do not matter if nobody enforces them. Budgets do not matter if services never reach the people who need them. Investigations do not matter if the findings disappear. And rights do not matter if institutions can ignore them without consequence. That's why we keep following the record. I'm Michelle Evans. Thank you for watching, reading, and supporting independent New York journalism. Share this episode with somebody who needs to see it. And join us again next Sunday at 6 p.m. Eastern for another edition of the NY Weekly Record. Until then, stay informed, stay loud, and never stop asking who is being held accountable.